welcome to Lawyers Info Hub. It's always a pleasure to create content on this platform. You are welcome. If you're a returning subscriber, I thank you for always stopping by to check what is new on the channel. And if you're seeing us for the first time, this is Lawyers Info Hub. It's a platform where we create law content, we simplify legal terms, legal content, the most simplified way for ease of understanding. So today we're looking at partnership agreement. Someone comes to you to talk about, I want to have a business, I want to create a business, I want to collaborate with a lot of people to do a business. And as the lawyer, they want you to advise them, or he or she wants you to advise them on partnership and partnership agreement and all of that, and you're a bit confused. So today we're going to share what a partnership is all about, the partnership agreement, and how to draft it. These are the briefs you can just do within a snap of finger and earn your fees. If you're yet to subscribe, please consider subscribing to the channel. So when we talk about partnership, what are we talking about? What is partnership about? You know, partnership is an organized structure. Yes, an organized structure involving two or more people to carry on a business and make a profit. Now, partnership is regulated by the Companies and Allied Matters Act of 2020 as amended, and now each state in Nigeria has their own partnership law. So, depending on where you practice, try and check it out. Now, a partnership can be formed orally or in writing, but it's in this time and age, and with what is the complexities of business is advised that it is the agreement is in writing. Now, the agreement is what stipulates the relationship between the partners. I know the agreement becomes, when it is signed, duly executed, it becomes a legal contract that contains terms and conditions that governs the operations of the partnership. And the law also presumes that there is in existence a partnership once that is the essential elements of partnership are present, in the agreement. So it's also important to note that the number of people that can come together to form partnership must not exceed 20. As well, you check out section 19 of CAMA. Now, how should you draft a partnership agreement? Now, when you're drafting a partnership agreement, there are certain things you have to place in mind that you must put to mind, and that must be at the back of your mind when you're drafting a partnership agreement. Now, the partnership, the intent, the intention, the aims, the terms of the objectives of a partnership A is different from objectives of partner B. However, there are basic things that should be contained in a partnership agreement. Now, what is the name of the partnership? Very important. The name of the partnership is very, you discuss with your clients, the people coming to, what do you want to name this partnership? You need to note it. And is this name that will be registered, in the with CAC? That is the name that should be on the certificate. Now, it's also important to note the details, the names of the parties. Who are those that we are going to form this partnership with? Details of the partners, their descriptions is very well important. So you have to note it and put it into perspective when you're drafting the partnership agreement. The name of the partnership, the names of the parties, the partners, their details very important, and their description. What is their role in the partnership? What are they going to be doing? Is this going to be in charge of marketing? Is this person going to be in charge of sales? Is it going to be in charge of getting investors and all of that? What, it has to be specific. So the person giving you the brief must be specific in terms of letting you know what each of the partners are bringing to the table. What is their work? What is their description? Now, what is the nature of this partnership? What is the business into? What is this partnership all about? So you need to note the nature of business that will be carried out in this partnership. Is very important because it's part of what you're going to put in the partnership agreement. Where is the place of this business? Where is it going to be run? Where is the business place? Is there do they have branches? Some of the branches outside the country? All those details you need to note them. When is the partnership commencing? Time of commencement is very key in drafting a partnership agreement. When is it commencing is very important. Now look at also the capital contribution. Who is bringing what? What is their capital to where there's no express provision in terms of who brings what. There's a presumption there's a presumption that there'll be quality in contribution. But sometimes in many partnership there may not be equal contribution of funds. So who brings what? Is this person bringing 10%? Is this person bringing 20%? It has to be noted. It has to be stated in the partnership agreement. So there should be a clause on this issue of what contribution. What is the capital of the partnership? What is the capital contribution of a formula, or what each partner is what bringing. They also put in issue of profit and loss. In any business, there'll be profit and loss. It has to be stated categorically in terms of how is the profit going to be shared, how is the loss going to be shared. That has to be it's critical, and it has to be part of the partnership agreement. So as a lawyer who is drafting a partnership agreement, you have to put in how would they share profit, who gets what, is it based on what you contributed, is it to be shared equally. These facts very, 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 very important. And if they're not sharing it equal, like as earlier stated, also note it if it's to be shared based on what you contributed, or it should be shared based on different whatever factor or whatever formula they're using. You need to note it there. Now, if property of the partnership, if they acquire a property, in whose name, how is it going to be? What is in whose name is the property going to be, and is it going to be the personal capacity, or the name to be in a partnership as in respect to the business. So partnership property is very important too. If the money used in buying the properties from the partnership, okay, if there is when the partnership time has come to a fruition, or when the partnership is no longer there, how are they going to share the properties? Also very key in drafting your agreement. Is also very, very key. Now, if in the partnership each partner brings in something, maybe to the office, this person brings a printer, this person brings a generator to run the office, this person brings all that. You have to also state if each of the partners can bring their personal effect, and in whose name should those equipment or instruments or whatever it is be. And if there's the partnership is no longer in existence, each of them is has the capacity to carry their personal stuff out, and also know how the property that belongs to the partnership will also be shared or sold, and the proceeds shared among the partners. However they want to agree, you need to note it and also put it there. Now, can issue of suspension and expulsion of partners. Can a partner in the business be suspended for misconduct, stealing, fraud, all those things? You need to note it. If there's no provision that they cannot be suspended or expelled, then no matter the misconduct, none of the partners can be suspended or what expelled. But in business, there should be kind of restrictions on what should not be done. You have to state it. For example, you can say for the fact that we are partners, none of the partner can go about doing similar business of the partnership. This is very key, so that one person cannot be taking away the customer of the business investors or clients of the business. So this kind of clauses can be put into the agreement to know that if you're a partner for the partners, they cannot own similar companies or run similar businesses. Then how they can get in new partners is very important. Admission of new partners. What is the agreement in terms of if you want your new partner to join them? What can the new partner contribute? Is there a liability? Is there any benchmark the person must meet before joining the partnership? These are things. Does the admission require the consent of all the parties, or just two of the partners? These are things that should be discussed, and you note it and include it in the what agreement. Then what's the duration of the partnership? Is it for 10 years? Is it for 20 years? Is it for 5 years subsequent to what renewal? Some people can say, okay, let's do it for 10 years and see how it goes. So the duration is very key. If there is no duration, it means as long as the partners are alive. So it's being in perpetuity, as long as the partners are alive. Or is the if there's anything that's in terms of age or whatever, just note it, the duration of the partner. So depending on how they agree, you note it down. When there's any issue, dispute resolution is very key. Put in that clause. If there's any issue between the partners, who resolves it for them? Where do they go to resolve it? Do they resort to ADR before litigation and all of that? You note it properly. Now, issue of retirement. Um, does it look also note it if the retirement of a partner ends the partnership? If one wants to retire from the partnership, what is the procedure? Do they need to give notice, or to just retire by themselves, or just quit? So these are things you need to note in the agreement to state if someone, these are the procedure the person have to go through. Now you have to note that in a partnership agreement, to ensure that all the partners signed a proper execution is key, so that what it is to be a presume that it is binding on. Now there are some terms that are just implied. In terms of where the agreement is silent on the issue, on the issue of equal capital contribution. Equal capital contribution, when the agreement is silent on this issue. Equal profit and sharing, it is assumed there should be equal sharing of profit and losses. Um, uh, the fact that if there is no proper express agreement in terms of remuneration, the partners are not entitled to what remuneration. But if they are, or you have to this clause is silent. It's assumed, it's an implied term that partners are not entitled to remuneration. So issue of a debt, bankruptcy of partners, suspension, retirement, uh, you know, it determines the partnership. But where you don't want it to be so, you advise the client that you let there be express provisions with respect to expulsion, retirement, bankruptcy, debt, and all of that is very, very what important. Now, how can a partnership be dissolved? Very important. It can be dissolved in many ways. It can be dissolved by either a friction of time. What is a friction of time? Completion of time. If the agreement was earlier stated for 10 years, at the end of 10 years, that's a friction of time, it comes to an end. If it's like a fixed term and all of that. If there is no express provision in that agreement, it is assumed that partnership can be any of the partners giving notice to others of the intention to dissolve the partnership. A partnership can also be dissolved because of bankruptcy or death of one of the partners. It can also be dissolved by application of one of the partners to the court for its dissolution. Um, Maybe where some of the partners are no longer capable in terms of age, in terms of sickness, in terms of sanity, and all of that. When one of the partner become a lunatic, you know, so any other person is like, this can't work. Sickness, age, death, and all of that. Where a partner willfully commits a breach of the partnership agreement, if the agreement says to express term and one of the partners goes against it as a breach, then it can be what dissolved. The court can also can also in its opinions that dissolve a partnership. You know, Now in Lagos State, the partnership law of Lagos State, section 34, in the court can, in just and equitable circumstances, dissolve a partnership. So just like I earlier stated, each state has their separate partnership laws. So it's also look out for the one present in the state where you practice. Is very, very well important. So dissolution of partnership is there. So you need to note the implied terms and the express terms and basic things that your client wants to be expressly stated. So the instruction of your client is what guides you into drafting a good and proper partnership agreement. But there are basic things which I've earlier listed that should be contained in a partnership agreement so that it can, protect the partners and expressly state the do's and don'ts, what is expected, what is obtainable, and what can make the partnership to grow and what blossom, because it's all about business, about profit and loss, it's about making money. So this class would help or has helped you, clear your mind and give you an understanding of what partnership is all about, how to draft a partnership agreement, and all of that. I just do hope that you've enjoyed today's class. And if you have any question, please drop it in the comment section. It will get attention. If you're yet to go to the channel, we have wonderful videos in hundreds, yes, on different issues of law, different legal concepts that will be beneficial to your growth as a law student, as a young lawyer, as an old lawyer. You need to excel. Do take care of yourself and know that you can be the best. Wherever you find yourself, you can be the best. The sky can be your starting point. Just have to just be resilient. Don't give up who you'd want to be. Do take care.